Okay, everyone, good morning. It looks like our attendee list has now leveled off, so thank you for joining us this morning. My name is Brad Power. I'm the Director of Programs with Municipalities Newfoundland and Labrador. Hope everyone is safe and practicing social distancing and keeping in their bubble. It's certainly a different time we live in now, but the silver lining to it all, it gives us an opportunity to do more of these type webinars and information sessions, which help us greatly. Just a couple of quick housekeeping notes before we start. The webinar will take approximately 30 minutes. It may run a little bit longer depending on questions. Speaking of questions, we will do a virtual Q&A at the end of the session. If you have questions, please type them into the chat function. You can access the chat function on the bottom of your screen. If it's not visible, just move your mouse and you should be able to see it from there. Those that are on the telephone, if you are not watching, you're just listening, feel free to send an email or text message to me directly with your question. My email is bpower@municipalnl.ca, or you can also text me at 709-763-4686. I also just want to make you aware that you can change the way in which you view this webinar. There are various options in the top right-hand corner of your screen. You can choose a speaker view, a gallery view, or whichever you choose to make it easier for you in this scenario. We're very interested in your opinion when this is all said and done. In fact, as a result of some work we've done internally, we have a survey ready to go, and it will actually open on your screen the moment you end the webinar. If not, I encourage you to check our follow-up email and follow the link to that survey. It will only take about 2 to 3 minutes to complete, but it will be very valuable for municipalities, Newfoundland and Labrador moving forward. So thank you for joining us this morning. This webinar, as you know, is brought to you by Municipalities Newfoundland and Labrador, but in particular M&L Advantage, which is our membership services program. We're pleased to partner today with Stewart McKelvey and 2 of their representatives. You would likely know these gentlemen. We have a partner with the firm, Ian Wallace, as well as Giles Ayres. Giles is an associate. Many of you would recognize Giles because he's been at many of our events. So the 2 of them are going to tag team this presentation today. So I'll now hand it over to Ian, and Giles, you can go ahead and share your screen.
Good morning, everybody. I hope everyone is safe and well at home. This is, truly an extraordinary time. First time I've had an opportunity in 30 years of practice to present on issues related to a pandemic. COVID-19 was declared a pandemic on March 11th, and the 5 weeks since then, we've had some extraordinary events, certainly well beyond, I think, anybody's contemplation. Where we are now is, we're at some point along the curve. We're not sure where we are. We're hoping it's flattening out. I think we'd all like to see the back end of it, but we don't know, and we don't know where it's going. A lot of us, I think, have had to deal with issues that we have not confronted before in the workplace. It's very dynamic. These are continuing to unfold. All we can do, I think, is make the best judgment at the time with the information that we have. Giles and I today are talking about certain employment-related issues. Some of these you may have confronted, some of them you may yet encounter. All of them have their challenges, and given the specific nature of a pandemic, the unexpected aspects of it, there really isn't a lot of history that we can rely on. We can look at the statutory regime that we have. We can hope that it covers some of it. The governments have moved quickly to amend labor standards, for example. They are trying to address some of the issues, but certainly there are a lot of gaps that we as employer council have concerns about, and we're really not certain where this will all wind up. I want to talk just very briefly about workplace safety. All of us would be aware that we have an obligation under the Occupational Health and Safety Act to provide a safe workplace for our employees. And conventionally, that addresses issues in terms of personal protective equipment. We haven't had to engage in what we call social distancing or safe work practices associated with not having too many employees in one area previously, the conventional situation of having somebody in the workplace with a communicable disease would have resulted in that individual being sent home and directed to stay away. Under the current situation, employers would not be asking for a medical clearance for that individual. I think anybody that is potentially symptomatic with COVID should be just directed to go home, to remain at home for a period of at least 14 days. And if asymptomatic after that, they could be required to resume work. If they are able to work from home, of course, there would be, and to self-isolate, there might be some services that could be provided. Very clearly, sending an employee home that is symptomatic is not a violation of the Labor Standards Act. It would not be a violation of the Human Rights Code. We're entitled to ensure that the remaining employees are not exposed to a risk of contamination. The Labor Standards Act was recently amended to provide employees with a right to a leave of absence where there is, for designated communicable diseases. COVID-19 is one of those. So employees that are unable to attend work because of COVID or are directed not to attend work because of COVID have their jobs protected. They're entitled to a leave of absence, and that leave of absence would extend to employees that have to remain home now to provide childcare or care for children who are no longer in school. So there's a broad arrangement whereby employees during these COVID times are able to remain at home, to avail of a leave of absence, to avail of some of the federal government benefits now, and not to have their employment jeopardized. As an employer, there are limitations, of course, on what questions we can ask of employees. If an employee is symptomatic but has not been diagnosed with COVID, I think as an employer we can ask certain questions around exposure, possible exposure to the virus, questions around travel, questions even, I think, around other employment. Ordinarily, employers would not have the right to ask employees what other work they may have, what other employment they might have. I think that's a fair line of inquiry now, where that other employment may represent a particular risk to the employees. And if they are at risk of having contracted the virus, then of course that's an employer-related concern. So during this pandemic, while there are limitations, of course, related to employee privacy, there's a broader range of questions that we are entitled to ask in relation to potential exposure to the virus. And I think even within that, the questions could be directed to arrangements in the employee's own home. So if they are working, continuing to attend work, if they have a partner or a family member that may be a healthcare worker, I think it's reasonable for employers to ask questions even around, what is the situation like in the home? Are they able to self-isolate from their partner or their family member who is working in healthcare? How do they manage that risk at home? And ordinarily, of course, that would be outside of any reasonable inquiry that could be made by an employer. If an employee that was sent home because of COVID symptoms tests positive, well, then I think as an employer, of course, we have an obligation to notify the regional health authority. We have an obligation as well to notify other employees that worked in close proximity to the ill employee. And we, of course, I think would ask the employee that tested positive to give us a list of his or her contacts, employees, or even members of the public that they might have been in close proximity with within the previous 14-day period. And with a positive diagnosis of COVID within the workplace, there should be particular measures, special measures taken around intensive cleanings. We need to ensure that a worker that has tested positive with COVID, that his or her workplace has been properly cleaned and sanitized so as to not represent a continuing risk in the workplace. I'm just going to advance the slide, Giles. I'm not sure I've got control. Okay. I want to talk a little bit about workplace refusals. Under the Occupational Health and Safety Act, all employees have a right to refuse unsafe work. That would be work that is likely to endanger their health or safety. This statutory right must be exercised in good faith. It's not a privilege. It's not a right to be asserted capriciously. But if there is a legitimate concern with health or safety in the workplace, it is a right that may be asserted, and there can, of course, be no reprisal for a good faith assertion of a right to refuse unsafe work. So if you have an employee that is tested positive for COVID, or even an employee displaying the symptoms of COVID, I think it would be reasonable for most of your employees to refuse to attend work if their work necessitates being in close proximity to that employee that's displaying the symptoms. That right would not be reasonably asserted if you employed a frontline healthcare worker. So nurses, physicians, nurses' aides, of course, are not in a position to refuse to attend work at the hospital because they might be exposed to the virus. That's part of their workplace responsibilities. Municipal workers that might be required to engage in frontline work, municipal enforcement officers perhaps, employees engaged in emergency response, paramedics, fire department. I don't think a reasonable work refusal could be asserted on the basis that they might encounter an employee that's contaminated or that has contracted the virus. A workplace refusal may be reasonably asserted if an employee had tested positive, had left the workplace, but the employer had not engaged in an intensive cleaning of the workplace. So whenever you have that situation, of course, there is going to have to be a particular protocol followed in terms of cleaning. That's a matter where the Occupational Health and Safety Committee in the workplace should be engaged. We don't, of course, given the nature of pandemics, have a lot of experience with work refusals during pandemics. In 2003, during the SARS outbreak, there were a number of work refusals asserted by flight attendants, ticket agents, custom officers, and by and large, those refusals were not upheld on investigation. During the SARS outbreak, employees that had a particular medical condition or pregnant employees or employees that were breastfeeding could assert work refusal, and generally that would be addressed by way of an accommodation if one could be made in the workplace. In 2011, during the H1N1 pandemic, there were similar issues around work refusals. A lot of those were addressed, as in the current pandemic, by public health officials giving a direction for employees just to stay home if they were potentially exposed to others with the virus. Anybody displaying the symptoms, of course, similar to the current situation, were required to stay home and to self-isolate or to go into quarantine for a period of time rather than to seek a medical note. So in terms of COVID, employees that still are required to attend the workplace, I think there is a reasonable expectation that employees are entitled to work through this period, assuming they are not in close proximity to employees that have contracted the virus or are symptomatic. And a work refusal, if asserted, will have to be treated through a process of investigation. A little bit more difficult to do that now that managers and supervisors generally, I think, also are working from home. The Occupational Health and Safety Committee may not be engaged as readily, but a refusal will have to be investigated and a determination made whether to sustain it or not. I'll speak a little bit about privacy issues. During a pandemic, personal privacy rights will necessarily have to give way to the public interest. There will always be a certain residual core of rights which have to be respected, but personal information that would have otherwise have been subject to confidentiality may in fact be intruded upon in order to deal with a greater public interest. So, personal information, which is protected under a TIPA and the Public Health Information Act, includes, of course, personal medical information relating to the physical and mental health of our employees. There are general prohibitions in respect of disclosure of personal health information. The Act, TIPA, specifically recognize that personal medical information. I think employers are absolutely entitled to make a report to the Regional Health Authority. In respect of other employees that may have been exposed or worked in close proximity to the individual testing positive, I think employers are right to advise those employees not of the identity of the individual, but of the fact that they may have been exposed to the virus, that they would have worked within the previous 14 days to an individual that tested positive. I think, given the nature of the workplace, in many instances, a disclosure to an employee that they had been in close proximity to an employee that tested positive may necessarily result in disclosure of the identity of that individual. The name, of course, should not be disclosed by the employer, but the information may in and of itself reveal that. But as employers, while mindful of our privacy rights, we have an obligation to ensure that other employees are aware of their exposure to the virus and risk, of course, of contracting COVID. In our workplace, we would look at what policies we have. Do we have a policy that would proactively allow us to disclose a positive test result? I think for most of us, that's unlikely. So we're not going to have perhaps the internal guidance that we would like. If we have an employee that's absent from the workplace, there may be questions raised by other employees or communication that has to be provided to other employees why those employees are absent. The employee, of course, could be sent home merely because they're symptomatic, because there's a suspicion of COVID, or maybe because of their own living arrangement, they have an exposure to COVID. We would not advise of the specific reason why an employee was sent home or why an employee had requested a leave of absence. Sufficient to say that the individual is not in the workplace and will not be in the workplace for the foreseeable future. But whether it's a leave of absence, whether it's a layoff initiated by the employer, that's not information that is going to relate to the health and safety of other employees. And that, I think that's not information that would have to be disclosed. Employees that are home, that are symptomatic but have not been tested positive, are to remain home, and they should remain home for the 14-day period. If, of course, they develop further symptoms of COVID, they should be tested to the extent that they're able. If an employee suspected of having the virus remains at home for 14 days and is asymptomatic, I don't think there's any requirement for a medical clearance before they would be permitted to resume work. If that individual sought to return to work early, prior to expiry of the 14-day period, well, then I think medical clearance would be insisted on. Ultimately, we're dealing with, it's called a novel virus. This is all very new to all of us. The balance between privacy and the health and safety of our remaining employees is going to be, forever a challenge. I think, in the past 20 years, there's been an increasing recognition of individual privacy rights. There's a lot of case law, of course, that recognizes that, but we're in a pandemic, and it threatens the health and safety of all of us. Particular individuals are going to have particular vulnerabilities. Anybody with a compromised immune system, anybody that's exposed, that has perhaps elderly parents in their life or young children at home, they're going to have particular concerns. And how we reconcile the balance between privacy and public health and safety is going to be challenging. I think all we can do under the circumstances is make our best judgment, having asked, I think, the appropriate questions, and making a determination that we think is reasonable and right in the first place. One way to sort of address any of these concerns, of course, is to ask your employee, an individual that is being sent home or is asked for a leave of absence. You can always say to that individual, we would like to make some communication in the workplace. Your co-workers, there's going to be a reallocation of work. There may be questions. There may be somebody that would like to know why is it that that individual, why is it that you are no longer in the workplace? And I think employees understanding that concern will be willing to have a certain amount of disclosure in terms of their current situation. It should go no further than what they would authorize, but ask your employees, ask your staff. You're going to remain home for 14 days. You're concerned you might have COVID. Can we indicate that to your workmates? Can we indicate that to your coworkers? And I think we'll all get through this. It's going to take some good judgment. We're learning things as we go. What we might understand now is not necessarily, what the situation is going to be a week, 2 weeks, 2 months from now. But I think if we, keep the basics in mind, be respectful of each other, try to keep a level head, I think we will get through this. Giles will take it over from here.
Thanks, Ian. And it's nice to be here on the webinar. Of course, I'd prefer to be seeing you all in person in the summer for the PMA and MNL conferences, but it's the best we can do. We are going to blow through our half an hour time limit, and you know, it's an important subject. I'm sure we'll have time for questions after. Ian and I discussed we're here as long as you need us. If you need to get off the webinar and you still have questions, you know, I'm sure all of you know about the MNL telephone advice line. You can give us a call for your 15 minutes of free guidance on legal issues if they relate to COVID-19 or otherwise. Both of our numbers are on our website. My number, my office number is going straight to my cell phone. You can reach me anytime. So I'm going to touch on some of the human rights issues that might arise because of COVID-19. So in Newfoundland, all employers, including municipalities, are bound by the Human Rights Act. And the Human Rights Act says that employers cannot discriminate against employees because of a disability. Unfortunately, the Act doesn't really define what a disability is. Courts have sort of attempted to do, and the Human Rights Commission have attempted to do that for decades, unfortunately without much success. What we can say is a disability is some sort of ailment or infirmity that's, you know, that there has to be some level of persistence and there has to be some level of severity. So based on these criteria and what the courts have said, we don't usually consider things like colds and flus to be a disability that triggers an employer's obligations under the Human Rights Act. Now, COVID-19, we think, might be a bit different because it does have a level of persistence. It can affect employees for some time, and it is quite severe. So, you know, as Ian said, this is an evolving situation. We're not getting any court decisions or Human Rights Commission decisions on whether COVID-19 is a disability because COVID-19 didn't exist 6 months ago. So what we can say is that there's a good chance that it might be, in which case the employer has a duty to accommodate an employee with COVID-19. Now, when I say accommodate, I don't mean that, you know, the employee has to drop everything to accommodate the employee. As always, the employer's duty to accommodate a disability under the Human Rights Act is to the point of undue hardship. Undue hardship is very fact specific. It depends on the employer. It depends on what the employee's duties are, and it depends on how the employee's restrictions can be accommodated. Fortunately, for COVID-19, there's two accommodations that spring to mind and people have been talking about, which are first, working from home, and second, extended leave. Whether an employee with COVID-19 is going to need to have a laptop issued to him or her, that's a specific issue that'll probably depend on the employee and the workplace and whether extended leave is going to be required instead. But this is the lay of the land as it relates to COVID-19 and human rights. So I'll just briefly flag one other human rights issue as it relates to COVID-19. We've seen travel bans imposed by employers in Canada, and we've seen mandatory quarantine periods imposed by both governments and employers if you come back from, say, Italy or China. But you know, what we will say is that employers should not impose broad policies based on race, ancestry, or national or ethnic origin. Travel, yes, other things, no. Just a flag. I'm sure many of you will already know that. So next, I just wanted to touch on the issue of workers' comp and benefits. So as most of you know, Workplace NL covers injuries that arise out of or in the course of employment. That's the phrase that's in the legislation, and unfortunately, like with what is a disability, we can run into problems in trying to figure out what it actually means. So generally, what the courts and what Workplace NL requires is a causal connection between the claimant's problem and the workplace. So there needs to be some sort of, you can't get COVID-19 at a supermarket and then try and claim workers' comp if you don't work at the supermarket. Second, employment has to be a significant causative factor in the injury. Or in the injury, or in this case, disease. So for people like paramedics, for people like doctors and nurses, we think it's pretty likely that Workplace NL is going to cover transmission of COVID-19 at work for these people. This gets a little more tricky in the context of municipal employees who come into contact with people who might have COVID-19 at work. And we think that there is a risk here that it might be a workers' comp issue if, for example, I think the example Ian used was a municipal enforcement officer who in the course of his or her duties contracts COVID-19 from a member of the public. In that case, Workplace NL might step in and say that this is a workplace injury. But again, we're going to have to deal with these situations as they arise on their facts. I put their entitlement to group health plan coverage just so it's sort of in your mind for employees who are forced to leave work because of COVID-19 and some of the issues that Ian discussed. There's nothing general that we can really say about an employee's entitlement to your specific group health plan coverage, because it's always going to depend on the actual wording of your health plan. But it's something to keep in mind if you have employees off sick because of COVID-19, that your health plan is there and you should have a look at it, see what it does. So we've seen a lot of this in the private sector, employees having to lay off, or employers having to lay off employees because of shortage of work. You'll see this a lot in retail recently. And we know as well that municipalities are feeling a certain squeeze because of property tax assessments coming up. So just to set out the lay of the land generally. So for unionized workforces, so if your employees are governed by a collective agreement, generally that collective agreement is going to deal with the issue of layoffs and termination, and it's going to deal with it totally. So your collective agreement might provide for the situations in which you can temporarily lay off employees. Again, just like with workers' comp, there's not much general we can say about that other than, it's important to have a look at your collective agreement and what it says in that situation. It's a bit more tricky for non-unionized employees. Generally, if your employment is not governed by a collective agreement, there's really no such thing as a temporary layoff. Most of the time, courts are going to consider a temporary layoff to be, a termination for the purposes of the Labor Standards Act. That means that employees who have been temporarily laid off, if they're not subject to a collective agreement, they are entitled to the either notice of that layoff or pay in lieu of notice, which depends on how long that they have been employed. And there's different periods of notice and pay in lieu of notice that are set out in Section 55 of the Labor Standards Act. However, one thing that we should flag is that there might be a COVID-19 related exception to this. Section 53 of the Labor Standards Act provides for a bunch of exceptions for when you don't need to give notice of termination. And one of these exceptions is where an employer is required to terminate employees because of, and I'll quote directly what it says, climatic or economic conditions that are beyond the foreseeable control of the employer or that necessitate declaration of redundancy. So again, this is one of these phrases that the legislature has come up with for us to tell you what they mean, and we're going to have a hard time doing that. There's similar provisions in other provinces' labor and employment legislation, and they all read slightly differently. In ours, there's no case law on point to guide us. We've generally taken the view that This provision applies if there's a government shutdown order in your workplace, if the government orders your workplace to close, this provision might apply. But now we're increasingly of the view that employers may have an argument that this provision applies because of COVID-19, which could well be considered an unforeseen situation that could necessitate the closing of many workplaces or the termination of employees. Again, this is a hazy view. This is the provision is worded in a complicated manner. There's no cases on point. This is a situation where when COVID-19 is resolved or resolving, and employees have been laid off without notice because of this provision, where they might make complaints to the Director of Labor Standards or sue their employers. And there will be decisions to help clarify this when the chips have all fallen. But at this point, all we can do is make educated recommendations. And in this case, this provision might be there for employers, but we can't rely on it with certainty. The other thing I'll say is that there are special rules that apply when an employer lays off 50 or more workers at one time. There's special notice periods, and in most cases, a requirement to notify the Minister of Employment and Advanced Education of the termination. And finally, I'll just touch on that, if you're considering layoffs or terminations, you should be aware of the various government support schemes in play. The wage subsidy, which you may have heard of, does not apply to public bodies, but the emergency response benefit and the new EI approach, still applies to workers terminated from public bodies. So it's important to turn your mind to those for the benefit of employees that are going to be laid off if you're considering layoff. So I think that's the last slide. So I guess now we'll turn it over to whatever questions you have that Ian and I can field.
Thank you, Giles. Very much appreciate the comments, and thank you to Ian as well. We will take questions on the chat function. The first one we have is from Jennifer Sams. How would the situation of an employee who has no sick leave be handled?
Yeah. Well, Jennifer, there is no under the Labor Standards Act, under the amendment that was passed by the House in March, employees are entitled to a leave of absence. Now that's an unpaid leave of absence related to a designated contagious disease, COVID being one of them. And that relationship can be indirect to the extent that the employee might only need to remain away from the workplace to care for elderly parents or a child in his or her care. So there is an absolute entitlement for that employee to avail of a leave of absence during the period of that public health emergency. If the statutory route is followed, there is no entitlement to pay. I would think as employers, if an employee had sick leave available, we would allow that to be extended. But entitlement to leave is not in any way dependent on having time in your sick bank.
Okay. The next question comes from Don Chaplin. How should municipalities treat annual leave requests during COVID, especially in light of the directives from the Chief Medical Officer? Can municipalities refuse requests?
I'll take that. I think if an employee is availing of a federal wage subsidy, then the employment presumably can continue. If the employee is going to avail of the Canada Emergency Response Benefit, $500 a week for 4 months, it would not be, I think in my view anyways, in the interest of the employee to avail of vacation. Typically, while under the Act, employers get to designate when holidays are taken, vacation is taken. Most workplaces have a practice or a policy around that where it would have to be agreed. If an employee requests vacation leave, if it can be accommodated by the employer, I think it should be. I would not expect that to be generally in the interest of employees who might otherwise want to avail of the federal benefit, the canned emergency response.
Okay.
Just to clarify Ian's response, so municipalities in Newfoundland will not be entitled to the wage subsidy provided by the federal government.
Okay. We don't have any other formalized questions, but I'll just remind participants that you can utilize the chat window. We do have one from Darren Finn in Grand Falls, Windsor. Would Article 53 of the Labour Standards Act apply to workers covered under a collective agreement?
So generally, the collective agreement is going to, can you hear me, Brad?
You're all good.
Okay, yeah. Generally, the collective agreement is gonna cover issues of termination and layoff for employees, and you would not look at Article 53 or Section 53.
Okay, thank you. One last call for any additional questions. I don't see any come in there now, so I would like to thank Giles and Ian for their time today. It's been a great presentation, and guys, you know, we very much value our partnership with Stewart McKelvey, so thank you for joining us today. Just a plug for the next webinar from Stewart McKelvey. It's on Monday. The registration has gone out, so check your email inboxes, and it's also available on the Municipalities Newfoundland and Labrador website. Thanks again for joining us today. Thank you to our presenters. The participants are what make this happen, so thank you everyone for joining us. M&L Advantage will be you know, continually offering webinars as we move forward, a bit of a change in the way we do business. So stay tuned for our public communique on those. If you do have follow-up questions following this webinar, feel free to email them over to me at bpower@municipalnl.ca, and I'll certainly forward them on to our friends at Stewart McKelvey. Otherwise, have a great day, everyone, and be safe and stay in your bubble. Thank you.